Patty Handy. I'm so happy you're here. Thank you for sharing your lunch hour with me. You're listening to KHTS, your hometown station, on AM 1220 and 98.1 FM. We're also Facebook Live at KHTS, so you can send in questions if you want to. And you can also download the app for free, KHTS app, and listen live anywhere. So the intro shared a little bit about starting over, but I wanted to sort of repeat that the show is dedicated for those starting over after divorce or loss of a spouse. Having gone through a divorce myself, I understand the overwhelm, the feeling lost, the roller coaster that you're on. And my focus is really to bring you tools, hope, inspiration, and navigate this time in your life. And as a mortgage advisor, I'm going to talk about money and credit, but I'm going to also discuss very important topics such as estate planning, financial planning. We're going to have different speakers such as personal trainers, motivational speakers, nutritionists, therapists, life coaches. It just runs the gambit. So make sure you tune in second Wednesday of every month at noon. And welcome. So Rob Mansour is a dear friend of mine. He is an estate planning attorney here in Santa Clarita. Right after my divorce, after I got my head out of the clouds, one of the first things I did was get an estate plan and a living trust myself. My son was 18 months old, and I wanted to make sure that he was protected and everything was known as far as my wishes go. So first, thank you for being here.
Thank you, Patty. Thanks for having me on your show.
I love that you're here.
I'm a little nervous. Is that okay?
It's okay. It's all good. You know what? Having lunch. We're just having lunch together.
Okay,
just
very good.
Minus the salad. So
yes.
It's all good. So explain to us out of the gate, what exactly is an estate plan?
Okay, so I think it's a good place to start because a lot of people hear the word estate planning, and some people think it has something to do with real estate. And I'm like, no, that's not what it is. And then some people hear the word estate planning and they hear that word estate and they think, okay, maybe I have to be really wealthy to do something like estate planning. And I think it's the word estate that misleads a lot of people. They think that they have to live in a big mansion and they're like the Rockefellers. I said, no, an estate plan is just a plan about what to do with your stuff. So whatever stuff you have, if you have $25,000 in the bank and that's all you've got, that's your estate.
Yes.
If you have $5 million in the bank, that's your estate. So an estate plan is a legal toolbox full of legal tools such as something you talked about just a second ago, a living trust, wills, powers of attorney, health care directives and health care documents, guardianship nominations for minor children. So a lot of clients don't realize that that is what an estate plan is. It's a legal toolbox full of legal tools, such as the things that I just mentioned.
Yeah, that's huge. The important thing for me, too, not only was the financial piece, but the medical directive. If something happened to me, who would take care of my baby?
That's right.
What was my wishes for that situation?
And you'll notice something. A lot of what I talked about has absolutely nothing to do with wealth. It has a lot more to do with who has the legal authority to act on my behalf. And that's really what this is about. It's about two things. That's what this estate plan does. Number one, who gets my stuff when I die? And that's what most people think about. But the other more important thing is who has the legal authority to act on my behalf. And a lot of people think, oh, my spouse has that authority. No, that's not true. Or they might think my kid has that authority. No, that's not true. It's whoever has the legal documents to act. So even when I called my wife's credit card company to get information, I wanted to find out what her balance was. They wouldn't share that information with me because I did not demonstrate to them that I had the legal authority for that information, despite being married. But that's just the tip of the iceberg.
So an estate plan obviously is important not just for those who are divorced, but everybody.
Yeah,
there isn't anybody that shouldn't have one.
That's right, because there's going to come a time when you're going to need somebody to act on your behalf, and you may not be able to do that. Or you're in the hospital or something like that, or after you pass away, who's going to get your stuff and how are they going to get it? Especially if you have minor children, you want to make sure that they get those things in a responsible manner, just like you were concerned about Blake after your divorce.
Right.
18 months old, oh my goodness, you need to create a plan.
Yes.
Yeah,
Yes.
absolutely.
So on that note, if somebody is going through a divorce or recently divorced, when is a good time to get this done?
Okay, so sometimes I get clients who call me literally the day after they get the divorce papers. I want to do my estate plan. I say, well, there's not much we can do yet because the dust hasn't settled. We still don't know what's his, what's hers. How is the estate going to be divided? So you can't really do too much until everything has been divided. You have your column of stuff, he has his column of stuff, and then you can say, okay, now that I have my stuff, my assets, now I'm going to make a plan with respect to those assets. I had a client one time, he called me and he said, listen, I want to move the house, excuse me, I want to move my house into a trust. I say, well, your wife's name is on the house. You can't just move it unilaterally. Oh, I can't do that? No, you can't. So I said, wait, when the divorce is over, then let's sit down and create a plan. So I think that would be the when.
Okay.
Yeah.
And I would imagine you would be separating, obviously, through the divorce, the house,
Yeah.
the banking, the debts,
IRAs,
the whole
yeah.
caboodle.
Yeah.
So that leads me to the next question. How is the vesting? How should you, I know there's a medical term for that when you put your title into that trust.
How do I do it?
Yes.
Okay. So let's say I'm John Smith, and I just got a divorce, and I have this thing now called the John Smith Living Trust. And the John Smith Living Trust says, hey, I'm John Smith. This is my stuff, and this is where it goes when I die, and this is who is responsible if I can't act on my own behalf. Now I have assets. The document itself doesn't have any magical properties to it. You actually have to go move your assets into the name of the trust. So that requires signing a new deed to your real estate, for example. So instead of the house being owned by John Smith, it's now going to say the John Smith Living Trust dated blah, blah, blah. You have to go to the bank. You say, hi, I'm John Smith. I have this living trust. They have to move the accounts from your name into the name of the trust, which requires paperwork. A lot of people make this big mistake. They don't fund their trust.
Funding, that was a term I was
Yes,
looking for.
funding.
Yes.
So they create this thing. It's like building a house but never moving into it.
Gotcha.
They build the house to their specifications, all the things they want, but they never move into the house. So my question to them is, well, what was the point of building the house?
Why do you have a trust? Yeah.
Yeah, why do you have the trust if you haven't moved things into it? And that requires paperwork and a little bit of legwork.
So the vesting on the house should be the trust, the vesting on all the assets, the checking, the savings, the IRAs. Is the IRAs?
No, the IRAs are a special animal.
It's a different, okay.
That's right. I tell clients to imagine that there are two funnels. One funnel is called the living trust funnel, and some assets are going to pass by that funnel. Other assets like life insurance and IRAs, all they care about is what you put on a beneficiary form. So especially after a divorce, you want to revisit that, because what if your ex-spouse is still your primary beneficiary on a life insurance policy?
So believe you me, I visited that.
Or what if your ex-spouse is going to get your IRA? It's probably the last person you want to get your 401k.
Yes, sir, Bob.
So those assets, you have to change the beneficiary. Now, the beneficiary can be your living trust. And for people with minor children, I think that's a good idea, because my kids, for example, are 20 and 18. My life insurance policy is not payable to Alex and Veronica Mansour. Those are my kids. It's payable to the Mansour Family Trust, because there's no way in heck I want that money to go directly to my kids at such a young age.
And the trust dictates when the money goes at what age to the kids.
Exactly. And also, if you build it right, it also says when it doesn't go to the kids. So, for example, what if my son is in a bad marriage? Or what if my daughter is in the middle of a lawsuit? Or what if one of my kids is disabled and shouldn't receive any money for some reason or another? There are protections that you can build into that living trust to protect your kids. Oh, also, speaking of minor children, you may not want your ex-spouse managing the money for your minor kid.
Right.
So for what you could do is the John Smith Trust, you can say, my brother Jack shall be my trustee. And so John's kids can get the money, but his brother Jack will manage the money for the kids, not John's ex-wife. And that's especially important when your ex-spouse wasn't good at handling money, or you suspect they're going to take the money and go to Vegas with it.
Right, right.
Yeah.
Yeah, that's huge. So you have to name who you want to manage those funds. And
That's right.
Again, part of the trust that, again, protects your kids.
That's right. That's exactly right. And also, don't just name one person. Name a deeper bench. Have like 2 or 3 people, just in case the
Something
person you've
happens.
selected can't
Yeah.
do the job.
Yeah.
Exactly.
So should you ever put kids on title of anything?
I'm not a big fan of putting children on title to anything. A lot of clients, after they get a divorce or they lose a spouse or something like that, they'll start putting their children on title. There are 3 or 4 reasons why that's a bad idea. Whenever you add somebody to an asset, so let's say Mary puts her son Johnny on her house, okay? If Johnny gets into any trouble, Johnny gets into a lawsuit, Johnny files for bankruptcy. Johnny gets a divorce. Something wrong happens to Johnny. Her house is now has a bullseye on it because she put Johnny on there. Also, if you put somebody as a co-owner with you, like on a bank account, there's nothing to prevent them from walking into the bank and just taking your money and going to Vegas with it again.
Oh boy.
Also, if you have multiple kids, let's say you have 3 or 4 kids and you decide to put Johnny on title, when you die, Johnny gets all of that. And maybe Johnny doesn't want to share with the other kids for one reason or another. So I'm not a big fan of putting children on title. Now, there is one caveat. If you're kind of nervous about stuff, put most of the stuff in your trust. And then create a very small baby account with like $5,000 in it or $2,500 or something like that, and put one of your kids on title to that. That way the kid can help you write checks, can help you do this or that, has access to immediate cash. But don't put them on the larger assets. Keep all of that in your trust.
Okay, that sounds good.
Does that make sense?
Yeah, absolutely.
Yeah. And there are other tax ramifications, but it's too complicated to get into on the show.
Okay.
Yeah.
So I want to revisit one thing just to make sure I understand it.
Yeah.
On an IRA, 401k, those things are such that the beneficiary should be the trust, not the child's name.
It depends. If you have 3 grown children and they all have good heads on their shoulders and they're all in their mid-30s and they're doing fine, nobody's got any problems, name the 3 kids.
Okay.
Make life easier for everybody.
Okay.
But if you have minor children, or if you have a child with a disability or some reason where you might want to protect the kids, you might want to name your trust as the beneficiary. And there are a lot of caveats to that, but the point is the shortest distance between 2 points is just naming the child, naming the individual that you want that money to go to, but only if you think that they're going to be okay. You know, there's not any trouble on the horizon and all the kids are doing fine. I like to, my trust is my secondary beneficiary. So I have my wife first, followed by my living trust. Why my living trust? Because my kids are still kind of young, 20 and 18. I would much rather wait until they get to their mid-20s, late 20s, and then say, you know what, I'm now going to put them as individual beneficiaries. Life insurance is different. When you pass away, the life insurance company just writes one big lump sum check. It's not the kind of thing that gets doled out over time like an IRA. So what I do with life insurance, I just say name your trust as the beneficiary. They'll just write a big fat check to the John Smith Living Trust, and then the John Smith Living Trust will say what happens with all that money.
Okay.
So I hope that helps a little bit.
Yeah, absolutely.
Yeah, that's what I usually say.
And then the person who you've dedicated in the trust to manage those funds would manage that life insurance
That's right.
money.
For example, I have $1 million life insurance policy. I'm worth more dead than I am alive,
Yeah,
right?
you may
I
both.
sleep with one eye open. So basically, you know, that money is going to be written to the Mansour family trust when I die. Now, if my kids are there, you know, Uncle Charlie, my brother-in-law, will be managing that money for my kids, so that they don't have immediate access to it. That's why.
Okay, that makes sense.
Yeah.
Guardianship of children, that's also specified.
Oh, yeah.
And then speak about that, and then also before I forget, I want to talk about the probate piece. Some of that, I know we're kind of jumping ship a little bit, but the probate piece, isn't that also why a living trust is
Yes, a living
helpful?
trust helps avoid probate, but let me address the issue of guardianship first.
Okay.
So one of the things that you can do in your trust, especially if you've recently got a divorce, sometimes you may not want that ex-spouse to be the guardian over your children. I had a client one time whose husband, her ex-husband, was abusive. He was verbally abusive, not physically abusive, but verbally abusive. And so what we did is, in her will, we named other people to be guardians over her children, and we also said why the husband wasn't suitable. She explained why in her will, where she addresses the guardianship, why her husband would not be the best choice. Why is she doing that? Because at some point a judge might be reading that information. And it's a way for her to communicate to a judge why she doesn't think her ex-husband would be suitable. So in some cases you may not have much leeway because, you know, the judge is going to order the natural father or the natural mom. But there may be times when that person is not available or doesn't want to be the guardian of the kids,
True.
is an absent father, an absent mother. So you should name in your documents who's going to be legally responsible for your children. Now, with respect to probate, probate is something that happens if you pass away and you've got something just sitting in your name alone, like a piece of real estate, and it's just in Patty's name. That's all. It's not in your trust. There's no joint owner. It just says Patty on it, okay? In that case, I may have to go to court in order to get a judge to give that asset to your kids, to Blake, Okay? Why? Because I can't just walk onto the property and give it to Blake. I have to go get a judge's permission to do that. Now, if it was in the name of your trust, I don't have to do that because your trust owns that asset. So probate only comes into play if there are assets that are sitting in your name alone. And in California, the current rule is if it exceeds $150,000 in value. That's the current rule.
Okay.
But a lot of clients think that probate is a necessary evil. But the truth is, if everything is properly titled, either by way of beneficiary or by way of your trust, you will avoid the probate system almost all the time, which is a good thing.
Yeah.
You want to
yeah.
stay out of the courts.
Yeah, yeah, absolutely. And if somebody already has an estate plan, living trust, will in place, and they just want somebody to take a look, make sure it's current, they did it 15 years ago, 20 years ago, and they want to just have it looked at again, will you review documents?
Yeah, I do that a lot. Clients will come with a previous estate plan and they say, hey, listen, first of all, what does this say? And
Help me
is it any
interpret this.
good? And I will say, sometimes I tell the client, you know, this is actually very good, and you don't need to do anything. But I will say, if it's been more than like 10 years, at the very least, you probably want to freshen up the powers of attorney and the healthcare documents. And here's why. Even though they may be legally sufficient, and they're fine, they might be legally fine. As a practical matter, you present a very old document to a financial institution or to a doctor or a hospital, they might look at it and say, do you have anything newer than this? Do you have anything more recent? And it's not because of anything that you did wrong. It's just because their policy at that particular place might be, we don't honor anything more than 5 years old or more than 7 years old or more than 10 years old. And you might have to go to court to get that enforced, but boy, that's a big pain.
Yeah.
So as a practical matter, I'd say every 7 years, revisit what you have, especially if it doesn't say what you want it to say anymore.
Right,
you want
right.
to change guardians. You just got a divorce and you don't want your husband to have anything to do with this anymore. You want somebody else to manage the money for your child. So those are perfect examples of when you might want to do that.
Yeah, great point. If you're married and you have this living trust in place and you get divorced,
Yep.
obviously you don't want that trust to...
That's right. You want to renege it.
That's
You want to
void.
revoke everything and start brand new.
Start from scratch.
Exactly.
Yeah, I could see that as being a huge piece.
That's right.
Talk to us about remarriage. We don't have much more time, but I know this is another probably...
You meet somebody new, right? After your divorce, right?
Yeah. If you meet somebody new
Yeah.
and you remarry and you have blended families, second marriages, how does that play into...
That's a very good question. So now John Smith has his stuff, right? He made his own living trust, and he lives for a few more years, 5 years, 6 years, and he meets Sally, his new love, right? And Sally maybe has children of her own, and maybe she's also divorced. Maybe Sally has her own estate plan, and maybe she has her own living trust. So sometimes what I tell clients is, look, there's many ways you can go. I'm a big fan of his and hers trust, especially if people are getting married later in life and they already have their stuff. John wants to be in charge of his stuff. Sally wants to be in charge of her stuff. Sometimes what we do is we leave John's estate plan alone, but we make sure we include Sally now in some way. And then Sally sits down with me and she makes her own estate plan that includes John. And that way she's in charge of her own thing. She can make changes if and when she wants to, and he can make changes if and when he wants to. Now, after they get married, their new marriage, let's say 10 years down the line, John and Sally may say, you know what, this is going swimmingly. This is wonderful. We don't want to have his and her stuff anymore. We want to have ours. So in that case, we would just get rid of both of those trusts and we create the Smith Family Trust, a joint trust for both of them. But it's very important to address one elephant in the room. What happens when one of them dies? John has kids from a previous marriage. Sally has kids from a previous marriage.
Right.
So let's say if Sally passes away, what's going to happen to her kids? Who's going to watch over those kids? Kind of like the Brady Bunch. What if Carol Brady dies? You know,
Right.
what if Mike Brady dies? So we always have to talk about what happens if the first spouse dies. How are we going to take care of those children? Also, that's an example of where everybody gets along. I had a couple of clients where his children did not like the new wife. They hated her.
Oh,
They
dear.
despised her.
Oh, dear.
And so she said, well, wait a minute. If he dies first, I don't want them just looking at me waiting for me to die. You know, just like, hey, when are you going to die so we can get our stuff? So what we did is when he died, we created a plan that says, okay, his children are going to get X. They're going to get $100,000 each. And then they're going to leave her alone. So we created a plan that accounted for what happens when he dies first, take care of his kids, and now she rests easy knowing that she doesn't have to worry about those kids anymore. Or you can make a life insurance policy payable to those kids. And that way you've taken care of them, and that way the new wife or the new husband doesn't have to worry about those kids. So blended families, absolutely a must, where you want to sit down and create a plan. One last thing. If you meet that new spouse and you go meet the lawyer, both of you should come. The husband and the wife should come. And everything is above board. We create a plan that suits everybody's needs. And because it's really hard to devise something if just one person comes to my office.
Right.
So I always recommend that they bring both people.
That makes perfect sense. So just out of curiosity, in that case, how often do you see the desire to have one trust with the blended family versus his family, her family, and keep it separate?
Well, it depends on the situation. So, for example, I just did one. It was his and hers estate plans. Why did I do it that way? Well, because Kathy, my client, she had a previous estate plan from before. A lot of her assets were already sitting in the name of her trust. It was going to be a real hassle to retitle all of that stuff.
Sure.
And so what we did is we just tweaked her trust to include her new husband, and he did his own plan. Plus, they also liked the idea of having dominion over their own stuff. If he wanted to make changes, he could. He didn't need her signature, and vice versa. But then I have clients who are like, you know what? It's not going to be his and hers. It's just going to be one pot. The trust can still say what happens when one person dies and what happens when the other person dies. I would say it's about 50-50 where clients do his and hers, and the other 50% they just decide to start over with a brand new joint estate plan.
And I would imagine too that if both parties have no children, it's a little simpler in that there's not much as far as protecting the kids.
Fewer complications.
Yeah, there's
fewer complications.
less activity going on in that.
That's
so,
right.
Yeah.
That's right. And actually, the more details you put in the trust, or the trusts, and the estate plan, the less problems you tend to have. The problems that we see a lot is where the trust is silent on a particular issue. Or, people got it from LegalZoom or something like that. It's fine, but it doesn't say enough.
Yeah.
And it doesn't address things specifically enough. And so that's where you run into problems. And that's why when my clients come and visit with me, they're like, oh, my goodness, I didn't know there was that much to talk about. And I'm like, yeah, there's a lot to talk about.
There's so much. There's so much to that. We've
Exactly.
covered a lot of great information. I need to have you back because we need to talk about when a spouse passes away.
Oh, yeah.
And how to deal with that. And so I will have you back.
All right.
It's
if
been,
they'll let me back in the building, yes.
It's you know what, I think you're good. There
All right,
hasn't
good.
been anybody coming after us just yet.
All right, very good.
So thank you. Tell us where people can reach you.
Sure. My website is the best place to find me. There's a lot of helpful videos there, etc. The website is mansourlaw.com. So my last name, Mansour, which is MANSOUR, then the word law.com. And the phone number, if people want to call, is 661-414-7100.
Awesome. And I can attest to what an amazing individual you are. Not just brilliant attorney, but just a warm, kind human being that has the client's best interest at heart.
Well, thank you, Patty. You're going to make me blush.
So-
That's very kind.
I'll collect my $20 later. Honestly, I am proud to call you my friend, and I'm happy
Likewise,
that you
Patty.
that you
Thank
joined
you.
us. So you're listening to your hometown station, KHTS 98.1. Come back. We have a financial planner coming up on next half hour. Stay tuned, and we'll see you soon.
Satisfy your sweet tooth with a bite of sweet perfection from Nothing Bundt Cakes in Valencia. Their decadent cakes are ideal for your next birthday, anniversary, baby shower, wedding, holiday party, and more. Nothing Bundt Cakes makes their treats readily available without compromising quality. You can expect real butter and cream cheese, fresh eggs, and lots of love in each of their 10 luscious flavors. To order your own sweet treat, visit their Valencia Bakery in the Whole Foods Shopping Center or log on to nothingbundcakes.com.
Men, are you feeling tired, stressed, or just don't have the energy you used to? Did you know this could be related to decreased testosterone levels? Luckily, there's a safe, effective solution. Weeder Prime helps support healthy testosterone levels with clinically tested key ingredients. Just 2 capsules of Weeder Prime each day can help change your mood, energy, focus, body fat, and lean muscle. Feel the way you felt 10, 20, even 30 years ago. Rediscover your Prime with Weider Prime. To find a retailer near you, visit WeiderPrime.com. That's WEIDER Prime.com.
Patty Handy, host of Starting Over with Patty Handy, has written several books that speak to her audience. Money Rules 101, Master Your Money Before It Masters You, is designed for anyone seeking financial peace of mind, for themselves as a parent or their young adult children. In an entertaining and highly readable approach, Patty covers many topics, including the money mindset, debit and credit cards, understanding credit scores, entrepreneurship, spending wisely, secrets of savings, investing, buying a home, and most importantly, giving back. A must-read for anyone.
It's no wonder people love Baskin-Robbins, as it's known for its 31 flavors of ice cream. From ages 1 to 99, people visit Baskin-Robbins anticipating the pleasure of enjoying their favorite ice cream, served any way they want. They also create customized cakes for any occasion. With several locations in Santa Clarita, you're sure to find America's favorite neighborhood ice cream shop near you. Visit them in Stevenson Ranch on the Old Road, on Soledad in Canyon Country, or on Lyons in Newhall.
At Advanced Audiology, we know how important hearing is to you, your loved ones, your work success, your safety, and your ability to stay in the game. Most people won't admit hearing loss to themselves or others. We make it easy for you. Today's digital hearing aids come in a variety of styles, including invisible. All feature-rich, providing unparalleled hearing quality, wearing comfort, and automation that simplifies your life. Don't be fooled by our imitators. There's only one Advanced Audiology with the purple sign, next to AAA on Valencia Boulevard.
Arch MI is the leading mortgage insurance provider in the U.S. Mortgage insurance helps people buy a house with only a modest down payment. This is because MI protects lenders against the increased risk of borrower default related to mortgages with high loan-to-value ratios. Arch MI provides an array of products and services so our clients can originate more. Our competitive pricing tool, Arch MI RateStar, is a revolutionary mortgage insurance pricing solution that goes well beyond traditional rate sheets to provide competitive rates matched precisely to your borrower.
Now FM 98.1 FM and AM 1220, your hometown station.
You're listening to Starting Over with Patty Handy, Senior Mortgage Advisor with American Family Funding. Patty's show will focus on healing, inspiring, and empowering anyone going through a divorce or a loss of a spouse. They're talking about everything from money and managing finances, legal issues, emotional healing, physical well-being, and so much more.
I'll be the last one standing, 2 hands in the air, I'm a champion. You'll be looking up at me when it's over. I live for the battle, I'm a soldier. Yeah, I'm a fighter like Rocky. Put your flag on your back like Ali. Yeah, I'm the greatest, I'm stronger. Bet my dues, can't lose, I'ma own ya. Hey, I've been working my whole life.
Hey, and welcome back to Starting Over. I'm your host, Patty Handy. Thank you again for sharing your lunch hour with me. I am really happy you're here. You're listening to KHTS, your hometown station, AM 1220 and 98.1 FM. Also, Facebook Live if you want to ask questions of my next guest, and the KHTS app as well. So, as I mentioned last time, the show's dedicated to those starting over, loss of a spouse or divorce, and I'm really hoping to encourage, bring hope, inspiration, and help you thrive and navigate through this time in your life. My next guest is also a dear friend of mine I've known for many, many years, Mike McGrath. He is a certified financial planner and partner with EP Wealth, and we're going to talk about some financial pieces. Before we